So, good evening, everybody, and thanks again for joining us. Welcome to newcomers. Thanks for coming back to folks who've been here. And this is going to be the conclusion of our webinar series on my book, How Wealth Rules the World. And this is it for those of you who have only read the PDFs online, but they are there available if you'd like to read from that. And I'm going to cover the part of the conclusion of the book tonight, though I'm not going to read the whole thing because I'd like to make sure that we have some time to have a conversation. If you have any questions or comments, thoughts to share. This is the last of, actually the 11th of the series. And so if you've read the book or you've been with us all along, you kind of know the background. We're not going to have time for me to go back and recap a whole lot of material that's in the book. But I'm happy to answer questions and to further the discussion after the webinar is done. If you're interested and you want to contact me, ask questions or make comments, you can do that. And my email address is benprice@celdf.org, and I will get any messages from you directly. So we've covered all of the text of the book, and the last section that we covered had to do with property's international empire. And property has been a real focus of the book. The subtitle is Saving Our Communities and Freedoms from the Dictatorship of Property. And why property? And what do I mean by that? And what I'm speaking of specifically, and what we've been talking about throughout the book, is a special kind of property that I've identified as privileged property. And that's property ownership that, by coming into ownership of land or other types of property, especially in the past 150 years, corporations, which are a type of property, actual legal rights have been bestowed on certain types of property. And those legal rights, in the case of corporations, those legal rights are actually Bill of Rights protections, because the theory of the court back in 1886 is when it started, was that corporations as a form of property were also legally persons. And as persons, beginning in 1886, the U.S. Supreme Court began to interpret the Constitution, beginning with the 14th Amendment, as applying to corporate property, protecting it. And the two provisions in that constitutional amendment that was ratified after the Civil War recognized that all persons have a right to equal protection of the law and due process of the law. And the courts applied those rights to corporate property as though the corporations were human persons, not just actually legal persons, which was a legal fiction that was found to be convenient when it came to things like ships that were owned by multiple people and other sorts of things that one owner wasn't easily identified. And the corporation of the ship, for instance, or the corporation of the East India Company that was chartered in 1600, those corporations were given the authority to sue and be sued. And that was shy of giving them actual constitutional rights under the 14th Amendment. Matter of fact, prior to the 14th Amendment existing, there was that kind of corporate personhood. But since then, corporations have taken on the Bill of Rights protections of human beings to the point where they now have the rights of religious freedom and freedom of expression, First Amendment rights, So much so that now, since corporate property cannot actually speak, it doesn't have a mouth or vocal cords, it's actually been determined by the Supreme Court that the money they spend to express an opinion, that's the form of speech that's protected by the First Amendment for corporate property. And the more involved and the more tenuous these Supreme Court decisions became, the more ludicrous some of us began to see the application of constitutional rights to corporate property. And there's been a lot of mischief that has come out of that. As we know, elections are now pretty much in the hands of whoever can apply the most money to back a candidate, a party, or in lawmaking, the amount of money that can be put behind passage or defeat of a legal measure. These are really impacting the way that governance works in the United States of America. I'm going to begin reading a little bit from the conclusion of the book, and then I'm going to cut off after a bit, ask if there's some questions, read a little bit more, and then I'll stop and we'll have a conversation. So let me go ahead and begin. The conclusion is titled, Community Rights Challenge the Dictatorship of Property. And as I do with each of the chapters, I head this conclusion with a quote from Sally Kempton. It's a quote that I came across years ago in the 70s. Sally Kempton is a feminist author, and she wrote in a book that this line struck me and has stayed with me for decades. She said, "It's hard to fight an enemy who has outposts in your head." In other words, if we are taught that whatever the Supreme Court says is the way it's supposed to be, for instance, or we're taught a history of the United States that is very positive and laudatory and leaves out kind of the messy parts, that causes us to think a little bit differently about the way our government and the real world works. So it's important, I think, and one of the main reasons for me writing this book was to kick the deceptions out of our heads, to actually let's be adults and look at the world with the rose-colored glasses taken off. Let's see what it really looks like, and maybe we can then understand what we're up against when our communities, for instance, try to not just protest, but actually halt a proposal that will be cited in their community that the residents of that community understand will be a real detriment to them, their quality of life, their health and safety, their natural environment. So I'll read on with the conclusion, at least some of it. To revise the future, challenge the past. Let the American Revolution resume. We can end the dictatorship of wealth through legally privileged property when everyone has unencumbered and equal authority to participate in making decisions for the communities where they live. It's time to pick up where Thomas Paine left off. We can, as he urged his contemporaries, begin the world over again. Knowing how wealth rules the world is one thing, deciding what to do about it is another. The urgency to make that decision has never been greater. Humanity has separated itself psychologically, intellectually, and ethically from the natural world. The human population has reached a size that is crowding out habitats for most species on the planet. We're exploiting the forest, soil, waters, and air in a way that is propelling us inexorably toward a great die-off of life. There's a growing likelihood that our habits of consumption will culminate in our own distinct extinction. Doing nothing cannot be the choice we make. It's time for us, the commoners, the regular folk directly affected by governing decisions to start governing. James Madison and his Federalist allies at the 1787 Philadelphia Convention worried that the wealth of what Madison called the opulent minority would be insecure if a constitution establishing democracy were adopted. He he should have worried that forming a government that places riches above rights would perpetuate tyranny. It's unlikely he could have foreseen the other dire consequences of protecting privileges for the wealthy few above all other things. Rights and property privatize the law, mock justice, and make abuse of women, minorities, foreigners, the poor, and the whole planet into collateral damage in the battle for absolute control by the smallest of minorities, the propertied overlords of America and the world. What can you do to help legalize democracy, protect unalienable rights, legalize sustainable communities, and sustainable and regenerative rights for ecosystems? What is already being done? Fortunately, we have some answers to offer from a growing popular movement that is challenging the oppressive status quo, and you can be a part of it. Historically, to secure rights previously denied, America's oppressed populations and their sympathizers formed people's movements to challenge systemic injustice. From the abolitionists, suffragists, agrarian populists, anti-segregationists, gay rights activists, and others, we have learned many lessons. The movement to elevate the rights of people, nature, and communities above the privileges conveyed by law to a wealthy minority is already underway. In the earliest years of the 21st century, CELDF, co-founded by Thomas Lindsay and Stacy Schmader, set off on a path leading away from progressive strategies modeled on the efficiencies of corporate management. They abandoned the comfort zone of activism that is devoid of confrontation with long-standing property-based legal doctrines. They were joined by the late Richard Grossman, scholar, historian, and co-founder of the Program on Corporations, Law, and Democracy. Together, they explored the frontiers of what Richard called the hidden history of our nation. I joined that journey part-time in 2003 and full-time in 2004, so 20 years ago. There was a consensus among our small, intrepid staff that the standard strategy of reformers regulating harms didn't satisfy the need to protect basic rights. At best, the gauntlet of regulatory hearings and public comment periods preserved the appearance of a public process. But in the end, communities across the country were being shoved to the curb like roadkill, hit-and-run victims of a corporate state. It was clear to us that when reformers tried to improve outcomes for people and nature by being reasonable and negotiating with well-heeled abusers, they fail. That's because their interests get caught in the crossfire between money-making and common sense. The sad fact is, too many activists whose hearts are in the right place have come to believe that common sense means not asking for more than you're likely to get without an unpleasant confrontation. It's been a senseless strategy, a common error, and most of all, a loser. We parted ways with progressives trying to regulate the amount of harm people would have to tolerate within the existing legal structure. To us, common sense said there had to be a better way and that we had to figure out what that was. My colleagues and I at CELDF made a hard decision. No more begging for a little less violence to our rights, our communities, and the environment. No more settling for nominal concessions and pretending they were victories. We didn't start out knowing exactly what to do, but one thing was obvious. First, we had to decolonize our own minds and get rid of historically dishonest but deep-rooted assumptions about American law and government. Then we had to share what we learned with people who were ready for structural change, but weren't clear about what stood between them and simple justice. Richard and Thomas developed the first curriculum for what came to be called the Daniel Pennock Democracy School. The school was named in honor of a young man who died in 1995 within days of exposure to urban sewage sludge dumped as fertilizer on a field near his home. Danny's parents, Antoinette and Russell, worked with us to educate communities about the dangers of this totally legal and state-permitted practice. The school was a Howard Zinn-style people's history expose of what we know about the origins of corporate power and the America that exists, rather than the one portrayed in lore and legend. The curriculum has gone through a few revisions since 2003, and as of this writing, we're working on new educational tools for communities across the country. And as of this speaking, those new tools are very much in development, and we hope to be sharing them out, hopefully this year. Although the weekend democracy schools were engaging and always generated personal epiphanies for people in attendance, we knew that deconstructing what went wrong in America wasn't enough. If we were going to be a think tank untangling the mechanisms creating social and environmental injustice, we'd have to take what we learned into the communities in our own home state of Pennsylvania, share it there, and help people challenge the rules that make democracy and local self-government for the protection of social and environmental rights illegal. We met thousands of regular people who were sick of being pushed around and forced to live with decisions about their hometowns that they had no hand in making. They didn't understand what was wrong and why it seemed impossible to get the law to defend their rights. We had some suggestions for them, and they shared their wisdom with us. We started in the rural center of the Commonwealth and heard from lots of municipal leaders and community members. They wanted to know why they couldn't stop factory farms from decimating their local agricultural economies, and why the state was encouraging farmers to use urban sewage sludge as fertilizer even after children had died from exposure to it. They couldn't understand how the state could continue issuing permits to waste haulers to legalize the spreading of poisons. They were sure the practice would stop once the state agencies heard their testimony and read the science. They learned that science and facts don't matter when they can contradict the imperatives of whatever Congress calls commerce. Here was our point of entry, an opportunity to talk with folks who'd been through the administrative meat grinder and been told there was nothing they could do. We explained how the law works and whom it works for, and why it doesn't generally work for them. Putting together a strategy to advance community rights grew from our encounters with people in communities under assault. We asked what they needed and what was stopping them from getting it. They helped us figure out the choke points that held local democracy and community self-government at bay. The answers weren't immediately clear, but we began to recognize one by one where the camouflaged roadblocks had been thrown in the path of democracy. We didn't know what we didn't know, and we had to free our own minds first to be able to see through the American jingoism to the stark truth of our predicament. That's the end of the first section that I'm going to read here, and I just want to pause and see if there's any thoughts, comments, or questions.
There is just so many examples, and I'm thinking of my own experience and the experience of my generation and my community that make me feel so many things about that passage that it makes me really want to know. I haven't read the rest of the chapter, so I don't know what you will have to suggest from that. What little I know about CELDF's history has been so interesting to me because of addressing those very things the way you have, and but you know that it's just such a beginning level, like moving to a next step is just uh, an interesting thing to know kind of what needs to happen to move to another step.
It it really did take some thought, and we started early on, actually in 2002, and it's mentioned in an earlier chapter. 2002 was the first year that a community adopted an ordinance that included language that challenged the legal Bill of Rights protections applied to corporate property. Um, and years after that, we began to expand that challenge and the language in local law, um, in order to elevate the rights of the community to protect their health and safety and to protect their local environment, their water, their air, their children's health, future generations. Um, you know, the fact that we have this administrative state that we have a lot of, and there's a lot of controversy around a comment like this, but the fact that we have a ministerial form of government, in other words, there is kind of a bureaucracy between the people in their communities and the people behind the corporations that come in and make a profit, in often, in many cases, doing harm to the community, that the corporations are actually issued legal permits that allow them to engage in that harmful behavior. And so there's the communities that we worked with over the years had a real sense of the unfairness and the injustice of the system itself. Not that it was just a corrupt system where there was money exchanged and somebody got a deal that they shouldn't have gotten, but sewn into the law, the way that it actually works every day, that when people went to regulatory hearings and they wanted to say, no, please don't issue that permit that'll allow this project to go forward because it'll harm us in these ways. Generally, the law had already decided that it was a legal thing for the corporation to do, that that the permit actually wasn't a matter of discretion for the regulatory agency and its employees, that it was a matter of, so long as the applicant for the permit kind of jumped through the hoops, filled out the right paperwork, supplied the right data, that they would get the permit as a matter of right. Folks that were involved in environmental activism tried mightily to put limits on what the permits could allow, put regulations so that what harm would be done would be minimized. It wouldn't be the maximum harm, it would be a smaller amount of harm. But the folks that we were working with didn't think that limiting the amount of harm was the same thing as protecting rights, that it was really a concession to commercial interests that said, well, yes, you can do the amount of harm that you need to do to make your profit, but no more. And the permit essentially is a license to do that. Certainly, if the regulations were strict enough that it disallowed a certain activity, then the activity wouldn't go forward. But that's generally not how they work. There are certainly some areas where things have been outlawed. But we know from just simple observation that since the 1970s and the establishment of the federal EPA and state level environmental protection agencies, that the environment, in fact, has been harmed more, not less. And I hope that that responded to your comments and questions. And Tom, I see you've got your hand up.
Yeah, now I am sympathetic with, but I think there's a difference between states and maybe between states. So I'm in Virginia, the northern Shenandoah Valley, and began promoting comprehensive planning as part of the Planning District Commission system that was begun in Virginia in 1968. And working with 5 different counties, the counties in Virginia that have chosen to protect their development, their property, have been able to do so using zoning ordinances, comprehensive planning, and going beyond that. So again, I don't know how much you in your work you've seen differences between states. I don't know that much about Pennsylvania, but my understanding is that counties in Pennsylvania can often be weak because they did not act in a regional manner, and townships did a lot of things and the counties just kind of laid back.
Well, thanks, Tom. Let me respond to it.
Sure.
So, and appreciate your comments. One of the things I would say about comprehensive planning, and we do have it in Pennsylvania, and I know you haven't joined us in the past so much, but I want to say that our work started in Pennsylvania, but we've worked throughout the country. These 20 years later, I've worked in a lot of states, and there's a common thread in terms of the regulatory system. Comprehensive plans, whatever state you're in, they're about setting kind of the vision for a community, whether it's a municipality or a county, and putting it on paper. The problem with comprehensive plans is that they are generally not enforceable law. They're visioning is what they are. Now, zoning is the creation of local ordinances that attempt to translate the comprehensive plan, the visioning, into, well, this is how we're going to stay on track to create these outcomes that we envisioned. But the problem with zoning is it is a very local form of regulation. And zoning law, I don't care what state you're in, zoning doesn't allow a community to say no to a project that the state legislature has decided it's legal to issue permits to allow. Zoning does allow the locality to decide where in their community those activities will occur. Now, state to state, there are some differences. I know in New York State, for instance, within their constitution, they have a recognition of municipal home rule as a legal concept. So that if a municipality in New York State says, we want to hold on to our rural quality of life in this little community, so we're not going to zone for and allow for heavy industry. In New York State, that is possible. But if that municipality allows any form of heavy industry, whatever it might be, they allow one in, now they must allow all in, because otherwise they would be sued for discrimination against the other forms of industrial activities. So corporations have rights. They have a right not to be discriminated against like they're human beings, and they can sue to stop that, even in New York. In Virginia, there is no recognition of municipal home rule authority. And just the opposite, if you talk with county level authorities in the state of Virginia, because we have worked there and we have some folks here tonight that live in Virginia and have been up against it all. Virginia identifies itself or teaches its elected county officials that it is a Dillon's rule state. And Dillon's rule says the state's dictates supersede anything you could possibly do at the local level, county or municipal. And if a locality, a municipality or county attempts to block a project that the residents find to be against their best interests, in violation of their rights, or harmful to their health, safety, and welfare. And the state has determined that it's a legal activity, that it is forbidden for the local community, local government, or county government to ban that activity. So sure, they can zone it. They can say, well, you can put it over here instead of over here, but they can't say no to it. And what we've come to the conclusion after lots of years working with communities across the country is that it's a violation of the right of self-determination, and it's anti-democratic for a board of directors of a corporation to sit down with regulators or with legislators to develop regulations and determine what must be permitted and allowed in every community in the state, whether or not the people living there want it. That we regularly heard that this seemed like a real violation of their right of self-determination, their democratic right of decision-making that sticks and is enforceable. That is, we now, of course, are used to living in a bureaucratic state. And the quote that I read at the beginning of this chapter goes right to this point. It's hard to defeat an enemy who has outposts in our head. If we were born into and grew up expecting this is how it works, well, this is how it works. Why should we question it? But how it works is it denies the right of people, and I don't mean just in Pennsylvania or just in Virginia, but all across the country. It disallows people from determining what their communities are going to look like when their grandchildren are growing up. And I'm not saying it's that the living generation should be allowed to stop anything from happening, but they certainly should be able to have the discretion on what is healthy and good for the community as opposed to destructive and harmful. So the point isn't that every community should make any decision they want for themselves without fear of preemption by the state. But when it comes to protecting rights and health, safety, and welfare, that they're primary, and people should be able to decide based on their discretion. That's called a democratic process, when you leave it to people's discretion, as opposed to experts who elected the experts, the PhDs, and even if we have wonderful science behind an argument that says, but this is safe, there's a difference between pure science, which is the study, the curiosity that looks for understanding and information, and applied science, which serves other purposes, which doesn't serve just pure knowledge, but it serves other purposes like profit making. That's when I hear someone say, trust the science, I'm likely to respond, I trust the science, but I don't always trust the people who interpret what the science says. I'm going to pause there for a minute, Tom, and I see V, you had your hand up for a while, so please go ahead.
Yes, thank you. Thank you for doing this program. I've got a question and some comments, if it's all right. And the first is, isn't there something in the Constitution about meeting in court the person face to face, which is impossible to do with the corporation? Has there been anything ever done about that brought up? You can't. I demand to see the corporation.
Yeah, I appreciate that. And how shall I call you? V? Is that okay?
Sure.
All right. So actually, yes, there is such a thing. It's called the Sixth Amendment, that someone who is accused of a criminal act has the right to confront their accuser. That's true. And in terms of corporations, the courts generally, and for everyone, not just for corporations, for all of us, the courts allow an attorney to speak on behalf of the defendant. And so that is how the courts deal with the question of confronting your accuser in a court of law, and having that right to do so. So, yeah, there are a lot of things that, by common sense, don't make sense. How can a corporation have religious views? Well, God knows. But Hobby Lobby was decided by the Supreme Court, and gave corporations the right to advance religious views. And so I I'm not here to explain the unexplainable. I'm here to wonder at it along with you, and also to challenge it. And I think challenging it is what we need to do, much more so than simply protesting it or questioning it. I think if we're going to actually be active citizens, then we have some responsibility to future generations, if not ourselves, to challenge the interpretations of law, or law in fact, that deprives people of justice and rights. You know, the U.S. Constitution was ratified recognizing the right of some people to own other people as human property, the right of government to deny all women any involvement in the governing process, the right to justify the genocide of the indigenous Americans and the theft of lands that they had occupied for millennia. We have that long history, and it's not unique to the United States, of course, but this is where we live. And so if we want to improve upon the past, and that's really, that was the opening lines of the conclusion of my book, is if we're going to, well, I'll paraphrase myself, but if we're going to define the future in a way that to create the communities we prefer to live in, we need to understand the past. And that was the purpose of my writing this book. I know there's a fair amount of history in it, and it digs into the Constitution and what those words say. What is that Sixth Amendment? What does it mean? What is that Fifth Amendment that has a takings clause in it that corporations sue municipalities over almost every day, if not every day, across the country? Takings clause that says, well, if you forbid us from the plan that we have for your community, stopping us from making the profit we had hoped for, that's government, your local government, taking our personal property, money that we could make, without compensating us. So the takings clause says government can't take private property for a public use without just compensation. But interestingly, the courts also stretched the law and decided that profits not yet made but anticipated could be considered property. So loss of future profits is considered a takings by local governments. If you stop a corporation from setting up some noxious business and doing harm to the community, but the state legislators have been lobbied and made it legal and have permits ready to issue, and the local government attempts to stop that from happening, they can be sued for depriving the corporate person of property without compensating them. What property? Property, that money they haven't made yet. The courts decided that actually is a property interest. It's a bizarre idea in my mind, because imagine you take a job and in I don't know, however long a time it is, you're laid off. What, can you sue that corporation for future lost profits, for money you could have made if they hadn't fired you and deprived you of your right to employment? Well, no, you can't do that, but corporations can do that when it comes to government depriving them of what they consider to be money not made but anticipated. Now, to be fair, corporations are not considered to be government entities, but they're not state actors. That came out of we talked about this some chapters back, 1883 court decision that said that only state actors can violate rights because the Bill of Rights is protecting rights against government violation, not against private violation. And so when a lynch mob would murder a Black person in the South at any time in our history, there was no violation of that person's rights according to law. It was murder, yes, and that's illegal. But it wasn't a violation of civil rights in the eyes of the law after 1883, because the court said, oh no, only states and state actors can violate rights. And so we can't currently hold corporations liable for violating civil rights because the state or the federal courts actually have declared them to be private actors, not public actors. And this, in spite of the fact that corporations are chartered, in other words, they're created by state government, corporate charters all issue from states. And every business license is issued by a state, and that empowers a corporation to do business in that state. And every permit legalizes the action that the corporation takes in a community, and that also is issued by the state. And then the law says, but they aren't state actors and cannot be accused of violating rights. My point, V, is that the law may seem superficially what we know of it to give us tools to work with to protect ourselves and to protect our rights. But as the law has not evolved, it's not an organic thing, as it has been engineered by the courts and legislatures, it has effectively protected the rights of wealth over the rights of people. I'm going to pause there for a second, and I see Meredith has her hand up.
Yeah, I just want to make sure I'm understanding correctly. So a corporation has rights that we can't violate, but they cannot violate someone else's rights. Am I understanding that correctly?
Doesn't seem fair, does it?
No. And I did have a question. Like, do you see a path to revoking corporate personhood? Like, is that a reality that we will ever actually see, short of doing things we probably shouldn't say while this is being recorded?
Oh no, you can say, well, you can say whatever you want, but I'm not going to advocate for the violent overthrow of the government. No, I am going to advocate for the peaceful overthrow of unjust law, and that's one of them. And personhood for a corporation isn't the issue. It is the application of, it is an issue actually in some ways, but prior to the United States government being formed, the English government and other governments recognized corporations to be legal fictions, in that sense, persons, so that they could sue and be sued, but not so that they could have rights other beyond suing and being sued. It was a way to use those corporations in an effective way. But let me also say, since I'm talking about corporations, that they were constructed, they were invented as many people here may have seen the movie Avatar. What's an avatar? Okay, it's kind of a shell that embodies an actual living entity, a person. Okay, and that's what a corporation is. It's an avatar for a group of investors that they can send out. I mean, not literally, because a corporation is nothing but paper, but that they can, in legal terms, send out into the world to do things in the world on behalf of the profit of its investors, and at the same time the investors are shielded from, they're made immune from responsibility for what the corporation does, because the corporation has been recognized to be its own person, its own legal entity. And as such, the real human beings hiding behind it aren't responsible for doing harm when the corporation is said to do harm. Now, is there a way to change that? The organization Moved to Amend came up with an idea for a national constitutional amendment that recognized corporations to be not persons and to not have constitutional rights. That has not got any traction from any quarter in the political world. Neither of the political parties that have held power since the Civil War have any interest in pursuing that. And I'll leave it to you to speculate why that is. And if you ask me, I'll tell you what I really think. But anyway, to answer your question, is there something we can do within the structure of government we have right now to fix all of that? Frankly, I don't think so. Because the system has been sewn up. The loopholes in the law are regularly plugged. And when they're not plugged, they get plugged when they find out that they should have. And as an example, in Ohio, I worked with communities in 8 different counties in Ohio. They wanted to put on the ballot a question for residents in the counties to adopt a home rule charter, which in the state of Ohio you can do. In Pennsylvania, where I live, you can't. But in Ohio, you can create essentially a local constitution for your county. And you can create it. It still has to be at least a representative or democratic form of government, and it can't violate the U.S. Constitution in various ways. But it does allow for the enumeration of rights, and it allows for a process of involving community members in decision-making in ways that states and the federal government do not. So these measures in 8 different counties in Ohio were drafted up and approved by the folks that were championing them in those counties. And then they went through the process of collecting signatures on petitions as is required. And they submitted those petitions to the boards of elections in those counties. And the boards of elections in those counties refused to put them on the ballot at the direction of political leaders in the state. Refused to put them on the ballot for reasons that were not in the law. They said, well, this is beyond the authority of a county to do this, to things that were in the proposed charters. The problem is that under law up until this point, it was not left to the discretion of the election officials to decide what was constitutional and not constitutional. In other words, they only had what was called a ministerial authority. They could check to make sure there were enough signatures. They could make sure that all the people who signed were really who they were. They could make sure they were registered voters and residents of the county. And they could make sure the petition itself was the correct form. But they could not make any other decisions about whether the petitions would push the thing onto the ballot. And yet they did. They acted as though they had the same authority as a court of law. They acted as though, and they presumed to have judicial authority to determine these measures unconstitutional before they even went into law. Now, when it comes to an initiative process, and I'm going a little astray here, but the initiative process is direct democracy in action. And when the people act on the initiative process in states where it's allowed, they are acting in the capacity of a legislature. The people, the residents, the citizens of the state or the county, when they petition for an initiative to go on the ballot, they have the same status as the legislature of that governing authority. And what the Board of Elections did in all 8 cases is they assumed the authority of the judiciary to block the legislature, the people as legislators, from doing their work. That was a violation of separation of powers right there. And yet the courts sided with the election officials, kept them off the ballot, and then passed laws to further constrict the authority of anyone in the state of Ohio from initiating legislation. This is the direction the nation is going in. And so, do I think it can be fixed by making new rules? We tried. We've tried not just in Ohio, but we tried in 8 counties in Ohio. We've tried in other places where people who don't have the legal authority to act as jurors, as judges, I should say, decided that they would refuse to do what the law says they must do and place measures on the ballot. If you can't get access to the ballot with your initiative measures, how can you possibly change bad law? The only way to do it is buy politicians, and I'm just not rich enough to do it. I know, there I said it, I editorialized. So, I see there's some comments going in, but I'm not pausing to read them. And perhaps, Michelle, if you see a question that needs to be responded to, if you could do that for me. I think you're still here, aren't you, Michelle?
Yes,
Yeah, there
yes,
you are.
I'm still here, and I've been responding to comments in the chat, as have others. So there's been some good conversation going on there.
That's great. That's great. Maybe I will take a minute and just read a little bit more if you would like me to do that, or would you rather just continue on the conversation? Speak up if you have a thought on that or opinion.
It's a good pause for some reading.
Okay. A little bit more then. The next subsection is called Unwelcome but Needed Epiphanies. In the United States, law is predictable. That's because the premises of the law are knowable. But even though they're knowable, many of the givens that shape the law's underlying logic have been ingeniously hidden from public awareness for a long time. This book has attempted to expose some of the obscure rules that turn participation in the republic by average Americans into empty rituals of democracy without the substance. There's a sense of stunned betrayal that's known all too well by people who take on the legal system to protect their hometowns, only to find out the deck is stacked against them. Until you join the ranks of activated and battle-tested citizens, it's easier to believe that however complicated the rules may be, they serve justice. Even repeated abuse at the hands of the courts, as they ignore the interests and pleadings of alarmed citizens, often fails to shake people's faith in the American justice. A kind of Stockholm syndrome takes hold. We've been taught to revere the men who wrote the US Constitution. Criticism of that sacred document takes most Americans out of their comfort zone. Nobody says, I demand a blood test, when the wealthy men who wrote the Constitution are referred to as our founding fathers. However, a lot of discomfort is generated by exposing the Federalists as counter-revolutionaries who are responsible for the repeated abuse of our communities and our freedoms. At CELDF, we concluded that it was time to develop a strategy that addresses the reasons we're powerless, instead of taking one more swing at the symptoms of our disempowerment. We knew we had to stop conflating the Federalist scheme for governing with the aspirations of democracy-loving American revolutionaries. That meant challenging everything from the borders and boundaries that created a wall of separating privileged property from community accountability, on up to the laws that make rights in things a higher priority than rights in people. We started about where the folk challenging the absurdity of corporate personhood have landed. That's why our first foray into confronting the system that favors privileges over rights was to draft a local law denying personhood for corporate property. But eventually we realized that although it makes sense to end the legal fable once and for all, corporations are not our main problem. They're just the most familiar type of privileged property. No, corporations aren't the problem. It's the people who hide behind that privileged property and reap all the benefits from the preposterous invention of rights for corporate property. My colleagues and I have worked with communities across the United States to write and enact local community Bill of Rights ordinances, amendments to existing home rule charters, and entire municipal charters. We've been met by furious opposition from attorneys representing moneyed corporations, nonprofit industry trade groups, chambers of commerce, and monopolistic media outlets. They've joined forces to sue citizens and municipalities to overturn or keep off the ballot local laws protecting community rights against their for-profit priorities. This cohort of the wealthy has had loyal allies in the courts, on boards of elections, and among secretaries of state. Still, our communities don't give up. They won't take no to democracy as an answer. As of this writing, proponents of county home rule charters, and here's the story I was telling, and local laws that have repeatedly been blocked from ballot access for shifting and inconsistent reasons, are preparing to sue the state of Ohio for violations of First Amendment rights and state constitutional rights to the initiative process. So what happened in Ohio? The people in Ohio in those counties sued the state, and guess what? The state moved the goalposts again and defeated the people and said, go home, you lose. So what's the point? If the courts and all the functionaries of government are going to block and overturn all our community's attempts to overcome the hegemony and dictatorship of property, why bother drafting and enacting community bills of rights? The short answer is that the struggle for unalienable rights is no place for those demanding immediate gratification. No people's movement in American history won equal rights for all merely by appealing for justice from the courts. It's not to be found there, even though the judicial branch is sometimes called the justice system. A few rulings by lower courts overturning local laws that protect unalienable rights don't mean a thing. Magistrate judges scrapping local legislation and imposing punitive sanctions on the attorneys arguing the case for justice won't stop the people from demanding their rights. And by the way, that actually happened. The courts have imposed fines on our attorneys when they have argued for the right of the people to protect their own rights locally against corporations that the courts claim have rights. They don't say it out loud, but they should say after that, rights that supersede the rights of people. The community rights movement is young compared with the struggles for racial justice, but there are strategic parallels. Being lectured by the courts that we've paid insufficient deference to long-standing legal precedent will not dissuade the drive for justice. Unjust precedent is unjust. It perpetuates injustice. We, the people, won't be governed by dead federalists. We will govern our communities and not be denied the right of local community self-government. And when I say dead federalists, I'm talking about white men of privilege with lots of property who wrote the laws, who thought it was going to be fine to constitutionalize the creation of human property, of slavery as a legal thing, of women as non-entities and properties of their husbands and fathers. That's the Federalists I'm talking about. And if that's who we want to keep calling our founding fathers, I do want a blood test. So there. Like the civil rights movement, the community rights movement's first job is to win the minds and hearts of the people. It's our job to expose for all to see the naked facts of official oppression, using tactics like the lunch counter sit-ins, the bus boycotts, and the local organizing for local needs. We've got to open people's eyes to see that it's not all for the best, that small towns trying to protect themselves are not just NIMBY-minded bumpkins that need to be put in their place for getting in the way of progress. Civil rights workers were accused of rocking the boat, of being too impatient for justice, and of showing insufficient deference to the rule of law. When the law protects some, but not all, and when it deprives every one of us our rights of self-determination, that species of enslavement to institutionalized oppression must be challenged and overcome. Community rights workers are sometimes condescendingly criticized by people who are as wrong-headed as those who fought tooth and nail against immediate desegregation and equal rights. Desegregation gradualists and progressive reformers alike advise against asking for too much too soon. But, quote, justice too long delayed is justice denied, unquote, as Martin Luther King wrote in Letter from Birmingham Jail. The persistence of injustice in America is nourished by the habit of trusting the legacy of the Federalist framers over the honest plea for justice of each living generation. Alexander Hamilton may have been right when he quipped that the voice of we the people is not the voice of God, but he had no qualms about replacing the voice of the people with the opinions of the Federalists, now long dead, and conjured again and again by the rule of precedent in courts of law. The Federalist Constitution made Africans property. It counted women as nothing. It sanctioned genocide for continental expansion. It made the whole of nature into property with no rights. It gave rights to privileged property and allowed whoever grabbed it by whatever means to enjoy those rights. It took from the people any practical means to reform, alter, or abolish government, as the Declaration of Independence said we must, when it fails to secure unalienable rights. It stole from all of us the sovereignty over our own lives and communities. Our freedom was not theirs to take, but it is ours to reclaim. The revolution is far from over. It was betrayed, and our natural rights as free people were never firmly secured. They remain to be won. Accomplishing that requires that we strip away the pretense of justice and bring the chains out into the open for all to see. That's been my purpose in these pages. We have no better place to start than to disconnect ourselves from the matrix of illusions and reconnect with the real world. And really, that's what it comes down to. We've been living under an illusion, under a delusion, and it's time for us to wake up. I know these are perilous times, and we can talk about that, and we should. And I think I'll pause there. That's the end of a short subsection. I'm going to do one more short one if we have time, but actually we're running out of time. And so I'm going to suggest that we go ahead and have a conversation here. And if you have some comments, thoughts, questions, let's go ahead and do that.
Well, Ben, Eugene put into chat that a question around, let's see if I can get back to it. It says, is the work of CELDF and democracy itself compatible with capitalism?
That's a really good question. I would say generally no. Is it compatible with socialism? I would say generally no. It comes down to a question of what's good for people and what's good for non-humans, what's good for the world that we're part of. And it's worth considering what indigenous people around the world have to say, because they figured out how to live without destroying the homes that they live in and are actually a part of. There are certain concepts of our culture that I think have set us off on the wrong path. And that path includes capitalism and socialism and, frankly, accumulation of material goods and wealth and the centralization of wealth and power. It's not these are not practices that have sustained living species, let alone humanity, for very long. And our ancestors, our human ancestors, generally did not use these techniques in their societies, in their communities. When I consider that we're killing the very planet that we depend on for life and poisoning its air and water, when I know that in my state of Pennsylvania, there are no streams where it's safe to eat the fish that come out of it, that it's recommended that you don't, or if you do, one fish a month maximum, something like that. I mean, this isn't natural. We have altered the ecosystem, and and I need to say this too. We work on rights of nature law, and it is one of I pioneered and helped pioneer that movement by working with the first community anywhere on the planet to enact a law recognizing the rights of ecosystems and recognizing that corporations' rights, as they were claimed, were not superior to those rights. It's a worldwide movement at this point, but I'm going to say that we have one thing wrong in the rights of nature movement. We shouldn't call it nature. It's an othering word. We are nature too. Everybody listening to my voice right now, you're all part of nature. We are all part of it. And you can prove it to yourself. Separate yourself from the Earth's atmosphere for 10 minutes and you're dead. Right? Stop taking in nutrition from other living organisms. And after 3 weeks, you're dead. Or is it 3 weeks or 3 months? I forget. 3 months maybe. And water. You know, it's my partner Kara quotes this to me all the time, the law of threes. I should get it right. 3 minutes, no air, you're dead. 3, what is it? Weeks, no water, you're dead. 3 months, no food, you're dead. These are our connections to the rest of the living world. And it's not other than us. When we kill nature, we kill us and our children and our grandchildren. So it's worth considering that and the severity of the problems we face. I don't think that they're being taken quite as seriously or anywhere near as seriously as they should be, or we would be making large changes very rapidly. I know that that's a difficult thing, and I'm not trying to suggest that we can just turn everything around that was put in motion. But you know, the Industrial Revolution is not that far in the rearview mirror. The big changes that have come from that account for so much of the harm that has been brought upon us. Does that mean we all need to give up our iPhones? Well, I don't know. I guess only if you care. But, you know, and by the way, oops, I got one right here. I'm not claiming innocence in any of this. We all partake in it. We're all complicit to the degree that we are. But we're also not responsible for the governing decisions that created these outcomes. We didn't decide it would be legal to set up a factory that dumps its waste into Lake Erie. We didn't create the law that says it's legal to clear cut an old growth forest and turn it into lawn furniture that will be in a landfill in 20 years. we didn't make the decisions that poison the water in our own communities, because we're preempted by state law from stopping it from happening, because that would be violating a corporate person's rights. Those decisions have been made at, as they say, a pay grade above ours. And they're not going to be changed, and this all can't be reversed very quickly. But we certainly have to stop its growth, just like you would a cancer. Something that is killing an organism by its constant growth, and growth is its main reason for being. It's the analogy I'm making here. That's cancer. And if our human societies and cultures are infected with, what is this cancer? Well, it's ideas, it's concepts. They're in our heads. It's the things that Sally Kempton said, it's difficult to fight an enemy when that's where they're lodged, in our heads. We can't easily separate ourselves from the belief that we were inculcated with from birth, that progress is good, that material progress is good, that growth is good, that more convenience is what we're here for, to create more convenience and to have jobs that are part of that process. It's a hell of a situation. And we need to be looking for friends to try to figure this out. I don't pretend to have all the answers to how that gets fixed. I do understand some of the causes, because I was asking myself, how could this have happened? Where did this come from? And I started out not knowing much, and I ended up knowing enough to put in the book what I put in it. And there's a lot more that can be shared. But honestly, all the information that we can pump into our heads isn't going to fix it. It's not about knowledge is power. It's knowledge is the fuel. Power is the doing. And the question is, what are we going to do? I see Gladys, you have your hand up.
That really did give me a lot of thoughts. And one of them is that big sense that is kind of reflected in the way you talked about the nature and humanity being part of each other. And I'm one of the things you taught me tonight was that was enshrined into law by our Federalist Constitution. And I did not really understand that until this evening. One of the things that was coming up for me that you about how are we getting out of this is figuring out what the networks are where other people are also working on these things. And I just read an article yesterday by a researcher who had done a lot of she'd done studies on whether a certain group of authors of books about this topic felt like a green economy was preferable to a post-growth economy, or vice versa. And the writers who were writing were very much in accord on the idea they have given up on the green economy, and they are saying the post-growth economy is the only way to actually get through this, which was very interesting to me. She was reflecting another study that has just been done that was a slightly different group. It's like the group she was talking about were writers on this particular topic. The other study was on like a different group of related people, but they had several hundred people in both of those groups that they could kind of look at. And yeah, they were both in agreement that we need to have a post-growth economy. That was just really interesting to me, because I feel like the economists and the thinkers in those areas are the ones who have kind of opened the door for capitalism the way they have, and that as wisdom settles into economy, that's a place where it's going to be harder to to manipulate that than they are people who don't know anything.
Well,
That's my
yeah,
comment.
I'll just respond quickly to what you're saying there. And yes, I think the so-called green economy is a latch, maybe not last, because folks who covet are very difficult to cause to give up their avarice. But the green economy amounts to an excuse for keeping going the direction we're going: growth, growth, growth. So electric cars better than petrol cars? Better? I don't know. Really, is being hung better than the guillotine? I don't think it's kind of a stupid question, right? And so is electric cars versus gas cars. Electric cars need lithium batteries, big, big, heavy, hulking batteries. And the lithium batteries, the lithium you can only find it in certain places in the world, and it has to be mined. Some friends of ours in the movement had been operating Protect Thacker Pass. It's a place in Nevada with a large deposit of lithium. They have been removed. They have been sued for daring to set up a latrine on land that is now being devastated with heavy machinery. It's going forward, and it'll end up being a crater, just a giant crater. And the leaching off from that site will destroy water. It's going to destroy Native American heritage, where there are 2 massacres on this ground, and it doesn't matter because the lithium's there. And lithium can be found in other places, by the way, that are the target of military campaigns going on. Why? Not to liberate people, as the stories go, but to get the lithium. And that's been the story of war forever. So not just post-growth is what I hear some people saying, but degrowth. I did see, Jam Dunk, thanks. I just saw as your comment came up, and they're just flashing up one at a time in front of me, the comments. But could CELDF be considered kind of a neo-Luddite group? Anybody know who the Luddites were? They're the folks that protested and employed direct action against early industrialization. I'm not going to speak for my colleagues, but I'm going to say, yep, I'm a Luddite. And the reason I say it, just like I'm a NIMBY. Remember when, if you were a NIMBY, not my backyarder, that you were just a selfish little person who was opposed to progress at all in any form, and just obviously a bumpkin? Not in my backyard, of course, because it's the only place that I actually have the authority to protect this place that we love, this planet. Not in my backyard, you betcha. And am I a NIMBY? Yeah, because growth without wisdom, knowledge without wisdom can be very dangerous. And we know that. And we see that right now. There are a few basic ideas that are at the heart of what they call Western civilization. And I'll name them real quickly. And if you want, look on the CELDF website under the column that I occasionally do, Wouldn't You Say? And it's, I think the title was something like 3 premises that doom Western society. And the first one is individualism. And it's a very American-centered thing. Rugged individualism, it's pioneer spirit. Yeah. Why don't you say what it really is? Genocide, ecocide, and lots of other things that we don't want to talk about. When I was a kid, Daniel Boone was a hero of mine. All of those kind of Disneyfied heroes. I'm kind of aging myself here, but that's okay. I already said I'm a NIMBY and a Luddite, so I'm also old. But the fact is that we need to purge ourselves of the idea that an individual by himself, herself, is what's most important in the world. Another concept is, it's a big one, the separation of advanced or industrialized humans from nature, the othering of the natural world, and our superiority to it. And from that concept comes the idea that nature and everything out there are resources and property to be owned. And the third is reductionism, the heart and soul of science. Am I saying science is no good? Nope. But I'm saying, just like social Darwinism, hey, evolution is an interesting idea, and Darwin's probably right. But when you apply that theory to society as though it, instead of biology, you have done something that's intellectually dishonest. And when it comes to reductionism, taken out of pure science for exploration and curiosity and employed as a practical tool, reductionism is a way to narrow down and only pay attention to the things you want to pay attention to isolate something from its natural context and say, this is the reality of it, when in fact, nothing, we can't understand anything out of its actual natural context. A human being out of its natural context is a dead lump of protoplasm because it's not eating, breathing, or drinking. And that goes with everything that you can separate from its context. It's a lazy type of intellectualism. I'm saying that reductionism is lazy intellectualism because what it does is it takes away the time dimension. It takes out the fact that the things we say in our own language, the language that we speak with betrays us as well. We noun everything, we other everything. Instead of seeing it as a being in process of becoming, whatever it is you're talking about, it's a thing reduced to its least common denominator. It's separated out of its context. This is pretty heady stuff, and I'm sorry to go there, but three main concepts. Have a look. It's a very short article, short for me anyway, and on the website, on the three paradigms or concepts that are dooming Western society. And this is really what I think indigenous people are talking about or trying to tell us. Their language, the words they think with don't other everything. Everything is a verb in their language, or most everything is a verb, not a thing, not a reduced, defined, ripped from infinity thing. So stuff to talk about. We have some changes to make in our worldview. That's what's going to change the direction, not a new constitution. We have to change what's going on in our heads. And that may seem like some kind of a stepping away from practical encounter with the political realities of the world. That's not what I'm suggesting at all. I'm saying let's start talking differently, thinking differently, acting differently, and making things work differently. We have to be very active about this. It's not an individual's, not just priority. It's not even I don't think it's my right to simply sit and meditate on how I can enjoy the rest of my existence without bringing something to the community of life that is around us. And that's a very unlegalistic thing to say. And I've written a lot of legalistic and historic and kind of intellectual things. But look, we're not just one thing, we're a lot of things. We're organisms, we're thinking beings, we're feeling beings too. We should embrace all of it. And tools are okay. I'm not an absolute Luddite. I like pencils, I can write with them. So I'm going to have to wrap up. It looks like we're running a little bit beyond. And I really appreciate everyone coming tonight and everyone who's been there for the long haul to, to maybe not all, but a lot of the webinars on the book. I hope you'll pick the book up and maybe learn from it. I really appreciate that the feedback that you've been giving me. And I'm going to give you a plug just for something lighter to read, because guess what? I have other interests, and well, no, they're all the same interests, but I think they can be expressed in different ways. And I do have actually a novel called Ogden, A Tale for the End of Time, that you might be interested in. You may not. Don't buy it if you really don't find fiction all that engaging, but I think I tried to include some of the concepts, but delivered in a different way in a fiction. And so, just a thought. And whatever you do, whatever you read, whatever you, whoever you talk with and encounter, I think it's time for us to start exploring seriously where we are and what our responsibilities are. We're the adults in the room now, and I think we need to start acting like it.